Good afternoon and welcome to today's webinar. I'm Beth Hawley with the Arizona Association of Realtors, and we're proud to bring you these free broker brief webinars designed exclusively to keep you updated on issues in the industry and AAR activities. Today's webinar will be an open forum where legal experts, AAR General Counsel, and local brokers will answer your previously submitted questions and touch on hot topics of the day. Joining us today is Scott Drucker, AAR General Counsel, Rick Mack, attorney with Manning & Katz, Nicole Lislavic, Vice President of Government Affairs, and Carrie Means, Designated Broker for Wise Realty Arizona. Today's presentation will be about 35 to 45 minutes. If you have any questions during the webinar, please write them in the question box, and we will try to get them answered at the conclusion. If you'd like to change the size of the webcam video, simply click on the line separating the webcam and the PowerPoint presentation and drag. As always, today's webinar will be recorded and available next week on our website at aaronline.com. So welcome and let's get started. So Scott, tell us about the new substantive policy statement on unlicensed assistants.
Sure. First of all, good afternoon, everybody. Welcome to our lovely library. We're glad you could join us today. One of our primary topics of today's webinar is going to be unlicensed assistants, and in fact, there is a new substantive policy statement on unlicensed assistants. It's number 2017.01, and it replaced a prior version of a substantive policy statement that also dealt with unlicensed assistants that went all the way back to 2005. In fact, the prior substantive policy statement was really viewed as outdated, and it didn't necessarily reflect everything that unlicensed assistants can and should be able to do in today's real estate world. And so AAR worked with the Arizona Department of Real Estate and Commissioner Lowe to develop the new substantive policy statement, which has been out for a couple months. So to start the webinar, we're going to kind of walk through the substantive policy statement, and I'll give some comments on it. The substantive policy statement starts like the previous substantive policy statement did with a definition of unlicensed assistants. And I'll just go ahead and read it for the record. It says an unlicensed assistant is an unlicensed individual hired by an Arizona licensed real estate broker or salesperson as an assistant who is not engaging in any activity for which a real estate license is required. The substantive policy statement then goes on to emphasize that unlicensed assistants cannot be compensated on a transaction-by-transaction basis. So, Rick, they cannot be compensated based on a closing. Is that?
That's right. You cannot have compensation tied to any sort of closing or a lease, for that matter.
Yeah. It then goes on, the substantive policy statement then goes on to list a whole bunch of activities that unlicensed assistants can do. And then on page 2 of the substantive policy statement, it lists activities that agents or unlicensed assistants, cannot do. And rather than go through everything they can do, we're going to focus on what they cannot do, because ultimately that's what gets everybody into trouble. So the first thing on the list is unlicensed assistants shall not originate documents. And what that means is that they cannot sit down and independently generate a contract, right, an offer, a counter offer. They can assist you in that process. They can perform administrative tasks, but independently they can't be sitting down and generating these forms. The next thing it states is that unlicensed assistants shall not perform a walkthrough inspection or a tenant vacate inspection. And this is a big one for property managers, because, Rick, we do hear about unlicensed assistants sometimes doing those walkthroughs for on behalf of the property manager.
Right, and it's also maintenance men, that sort of thing. We'll do a walkthrough to check for condition. Probably need to have a licensee do that because you're arguably practicing real estate. And let me back up.
Yeah, please.
The originate contracts, I get this call on the hotline quite a bit. What if you're an old fart like me who can't type very well? Is it okay to have an assistant type in the property address, the parties, the price, close of escrow date, so on and so forth? The answer I give is yes. That's effectively a secretarial or administrative function. You're not practicing real estate, so that typically is okay. So when it says originated document, it doesn't mean your assistant may not type. It just means your assistant may not use his or her discretion in creating terms for the transaction.
Yeah, and if you take a look at the items that an unlicensed assistant can perform, one of them very specifically is clerical administrative tasks, including typing.
Yeah.
So I think it would fall under that.
If you tell them terms, price, closing, so forth, yes,
right,
they may do it. But we get that call quite a bit on the hotline since this policy statement came out.
The next on the list is unlicensed assistants shall not provide advice, pricing or opinions of value to a consumer. You know, that's something that you as agents were taught to do, valuing properties. It's a bit of science, and it's not something that really should be left to unlicensed assistants. The next is provide advice or negotiate with anyone regarding a property or transaction. You know, whether you realize it or not, I think most agents have become experts in negotiating. And when a client hires the agent, I think it's their expectation that it's the agent that's going to lobby on their behalf and negotiate on their behalf when it comes to price, when it comes to repairs, that they're not going to take that and try to delegate it to an unlicensed assistant. Carrie, is that what you see? I mean, unlicensed assistants really are not in the position to be negotiating the terms on behalf of the client.
No, when your client's hiring you, they're hiring the expertise and that you know what you're doing, that you've had the training and stuff, and an unlicensed assistant hasn't went through all of the training, aware of the contract and stuff, so they want to hear it from the professional.
The next is unlicensed assistants shall not assist in the preparation of documents with a consumer. And the word with is in bold letters on the substantive policy statement because they can assist with the licensee, but it can't just be the unlicensed assistant and the client. That's what the Commissioner Lowe is trying to guard against. The next one is unlicensed assistants shall not hold or host an open house without a licensee being present. So they can participate in the open house, but it cannot just be the unlicensed assistant that's present. And I know, Carrie, you wanted to talk a little bit about unlocking the home and some of those issues.
Right, I mean, they can unlock the home, they can get it ready for you, and you want that second person there just for safety issues, especially, you know, in this day and age, so you're not alone there and stuff. But it's really easy to say, hey, I've got another appointment, leave 10 minutes early. If you're leaving, it needs to close. I mean, you have to be there the whole time.
Yeah, and one of the items on the list of tasks that unlicensed assistants can perform is unlocking a home. So that is something that is permitted. The next one is collect rent for the use of real estate. And this is probably the one that we get the most questions on because apparently it's fairly common for unlicensed assistants to take cash or checks, look it over, write receipts, issue the receipt to the tenant. Commissioner Lowe has been very clear that that's not permitted. If it has to do with money, she wants it going through the agent, the licensed agent, not through the unlicensed assistants. One of the things she recommends is, well, obviously if you can, have a licensee accept the rental payments. But she even went so far as to say maybe just have a drop box where they come in and drop the rent, put it in a basket, and that way it's not being received by an unlicensed assistant.
And kind of the precursor to that, the attempt to collect the rent even, and the hey, tenant, you're 5 days late, what's going on? That call needs to be made by a licensee as well.
Yeah. And then, Rick, I know this is one that you wanted to talk about as well, but assist or direct, unlicensed assistants cannot assist or direct in the procuring of prospects calculated to result in the sale, exchange, leasing, renting of real estate. And then it references an exemption that's in the statute, and it's a very narrow and limited exemption.
It is, and let me give you the Reader's Digest version. If you're doing the cold call stuff, where a lot of people are very disciplined, they'll spend 3 hours a day, every day, calling FSBOs and expired listings. If someone is doing that as their business model, it's very successful. People do really well with it. It's a lot of work, but they do it. If you have that model, you need to do it yourself as a licensee. There are at least 3 vendors that are providing service in town that I know of. There are probably more, but I've heard of 3, where they will do that dirty work for you. They'll do the cold calling for you, and they're based in Pennsylvania or wherever, and they're calling FSBOs and expired listings here. That is a violation. That is activity which needs a license before you can do it. If you're going to engage in that, there's 2 exemptions. Number 1, the licensee must do it. Number 2, and this is where Scott was talking about, it's very narrow. If the licensee wants to hire somebody who's unlicensed, well, let me back up. The person unlicensed has to be hired by the brokerage firm, arguably, not the licensee. The statute's a little bit vague, but Commissioner Lowe's position is that person needs to be hired by the brokerage firm, not the licensee. So if you're going to have an unlicensed person make those cold calls for you, that person has to be an employee of the brokerage firm. Nobody does that. There are several alleged violations out there that the commissioner is pursuing right now. I don't think people know that. That's a little bit of a sort of a niche in the marketplace. But be careful if you're hiring a third-party vendor, or if your agents are hiring a third-party vendor for cold calling. You are a DRE complaint waiting to happen.
Yeah, and if you're looking to get a better understanding of the exemption that Rick referenced in regard to the broker hiring, essentially the telemarketers, the statute is ARS 32-2121A10, and I would make sure that you and your agents read that statute very carefully before trying to apply the exemption. Our last one on the list is unlicensed assistants shall not attend closing with a consumer without a licensee being present. So can they attend a closing? Yes, but you have to be there as well. The licensee has to be there as well. It cannot simply be the unlicensed assistant and the client that are present at the closing. So that's our list on the substantive policy statement of items, of tasks that unlicensed assistants cannot perform. Anything that you guys want to add? I know we've got some questions that we'll answer later about that, but anything that you want to add at this point?
I have two. Class 5 felony if you hire someone who's not licensed and wants to practice real estate. So it is serious. I've never seen it prosecuted, but it's a felony, believe it or not. And the second piece is, we get questions on this one as well. What about the apartment complex employees who are collecting rent or leasing space and they get a commission? That is okay. There's a specific exemption in the statutes that says if you are employed by an apartment complex, you may in fact have a commission-based compensation program.
Yeah, and that statute is 32-2121A6. So again, you can take a look at that. That's it for unlicensed assistants for now. We'll come back and answer some questions, but Beth, I know you want to get Nicole involved in the conversation as well.
Yes, please. So Nicole, what's going on with the AAR's legislative agenda?
Well, thank you for asking the question and thank you for joining us. We're in the middle of the legislative interim, and so there is nothing going on at the state legislature currently that would affect our industry. But what we did just have last week was our Realtor Caucus, which we do annually, and I know that some of the brokers who are joining us today were with us then. And that was an opportunity for our members from across the state to bring forward legislative issues. With that being said, we have bundled up the package for the legislative policies. It's going to go to the Legislative and Political Affairs Committee this Friday. And then from there, it's going to go to the Executive Committee and then the Board of Directors in October. So annually, that is our kickoff, legislatively speaking. Some of the items that were brought forward were HOA issues, as always, water issues, which will be a big item for us to watch with regards to the governor's proposal. And then taxation. Taxation is going to be another big one that we will see potentially impacting our industry moving forward. One item that we did discuss at the caucus, and it's one of those things that you may have heard me reach out to you time and time again, is that as brokers, we need to motivate our agents to get involved in the mobile alert system. And the mobile alert system, I promise we will not spam you, but the simplest way to get enrolled is to text AZ Realtor, Realtors, or Realtor to 30644. And what this enrollment in the program does is it allows, when a large issue is before us that impacts our members or home ownership, it allows for us to reach out to the member directly and get them to quickly respond to a call for action. Just recently, we had one that issued from the National Association of Realtors on the National Flood Insurance Program. And unfortunately, the National Flood Insurance Program, CFA, got called short because the Senate and the House did a short-term reauthorization of the program. With that being said, it is not the 5-year extension that we would have liked to have seen, only 90 days. So that will be set to expire on December the 8th. And because of that, we will be seeing that come forward again from the National Association. I would suspect probably in early November. If you can, please get your agents to sign up for that program. If you are a broker who is not enrolled in the broker involvement program, also please reach out to me. I would love to assist in getting you enrolled. It takes all the work off of you, puts it back onto us, and allows for us to work directly with your agents to get our message across the finish line.
And Nicole, there was one other issue that came up at caucus, and I know you've been spending a lot of time on it, and it has to do with sign legislation, right? Municipalities instituting these sign ordinances, some of which are overly restrictive in response to the Reed versus Town of Gilbert case.
Correct.
You want to talk about what we're looking to do? Because I know you and I have both spent some time on this.
Yeah, I'd be happy to. So as Scott was saying, one of the issues that was brought forward at the caucus is with regards to for sale, for lease, for rent signage. And there are various municipalities that are trying to regulate through sign ordinances, which they believe comes into compliance with the Supreme Court ruling. It's of our opinion that some of the things that the municipalities are doing are overreaching or very burdensome and restrictive to the practice of real estate. With this in front of us, we actually went to the National Association of Realtors and presented a grant request. We wanted to have the best information and be best prepared in the event that we were going to move legislation forward. We were awarded a $75,000 grant and worked directly with Robinson Cole to do a study to see if we can outright ban cities from enforcing bans on for sale, for rent, and for lease signs. It was the opinion of the law firm that it probably would not withstand a constitutional challenge, but it was good for us to understand that information because it then provided us with the avenue to what could we look at that would withstand, quite honestly, a constitutional scrutiny in the Rules Committee in the House as well as the Senate, and then ultimately we don't want to have the legislation that we push forward suit. And so right now we are looking at legislation that does time, place, and use restriction. I am working with members of the legislature to see if we can obtain a sponsor. Through the last year, I've educated members of the legislature on this specific issue. I know that we have friends in the industry that have also spoken with these legislators. And ultimately, I do believe that we will have the ability to introduce the legislation and then we will go through the stakeholder process. I'm certain that the cities and municipalities are going to have some concerns with the fact that we are trying to do preemptive language, but we do feel as though it is an avenue where we can work together with them and provide comprehensive solutions that both benefits the cities and municipalities as well as our real estate agents. Anything to add on that?
No, I'm looking forward to the possibility of advancing legislation and specifically having in that legislation the ability to put our signs in rights of way, because that's been a big issue and that's been something that several of the cities, towns, municipalities have tried to ban. And as Nicole said, they will have the right to have time, place, and manner restrictions, right? You can't put a sign up that's going to block traffic or block someone's view as they're trying to turn the corner. So those sorts of restrictions would be reasonable, but just an outright ban saying you can never put a sign in rights of way, that's what we're trying to avoid. So hopefully that'll be a benefit to the members.
Correct.
Great, thank you. Let's get right to the questions then. So Scott, can you pay licensed assistants a salary and bonus on closings?
Okay, so I see what they're trying to do. They're in that instance, they're trying to have a policy. Well, we pay them on a salary, so it's not on a per transaction basis. But then they're giving the bonuses that are on a per transaction basis, right, based on the successful closing. And so my opinion would be no, you cannot do that because the compensation would in fact be tied to the outcome of a specific transaction.
Yeah, I think that's a no-brainer. Very clear, you cannot do that. Compensation tied to closing or a lease is not going to fly.
So Nicole, with the increase in teams and sizes of teams regarding broker supervision, is there anything the legislature is considering?
Thank you, Beth. Well, it's a very interesting question. I'm going to circle back to my earlier statement that the legislature is not in session right now. And so I have not heard anything specific as it is related to teams and the legislature moving team legislation forward. Probably we'll start seeing bills introduced in late November and December. And if we are to see something that does address this, it will go before the legislative committee for a position. And so right now at this time, the answer is no.
So Rick, will any of the Dodd-Frank CPA be changed or repealed as far as sellers offering carryback terms in the sales of their properties?
You know, if I knew that, I'd buy a lotto ticket and be rich by now. I don't know. The short answer is it's still the law of the land. There's still pretty significant restrictions on seller financing, one per year, and even with the one, you have some limitations. The short answer, who knows what's going to happen with the administration? As of right now, it's still the law of the land, and with the rate at which things are moving in Washington, I don't see it changing anytime soon.
Carrie, your agents seeing these seller finance transactions? Are you having them facilitate those deals?
We really aren't seeing them. Every once in a while, we'll get a question about them when they're still a little bit upside down and they're deciding whether to continue to rent it or sell it. And once you tell them what the restrictions are and the policies, they tend to go away with it and keep renting it.
Yeah, they're pretty strict, and Rick mentioned the one property in a 12-month period exception, which is difficult but not completely unreasonable. And then there's you can't do 3 seller carryback finances in regard to residential property within that 1-year period or 12-month period. That exemption is incredibly difficult to successfully accomplish. And so while we at AAR do have a form for it, exercise caution if you're going to try that sort of transaction, and maybe even consider going to Rick or getting an attorney involved.
Yeah, that's the one form I wish we could pull back. I don't think that it's been used more than maybe once or twice in the history of Arizona real estate. The other thing is, Scott hit it on the head, go see a real estate attorney. It's a risk shifting sort of idea. The Dodd-Frank Act is pretty complex. It's difficult to comply with. If you have a seller finance transaction, get that risk off of your desk, get it onto some lawyer's desk, because the risk, the downside of having a non-compliant loan document is rescission.
Right.
So the buyer, especially in a falling market, which may happen soon, the buyer can demand rescission if it's a bad document, and then the seller has to take the property back and give the buyer all of the money they've paid to date. So if you're a listing agent, that's a really nasty claim for you. So go see a lawyer. Don't do it yourself.
So Carrie, what are your best practices for assistance?
Well, we do address it in our policy and procedure manual. And the biggest thing is to sit down and talk to them. One, go over the policy statement so there's not even a question of what they can and can't do if they're going the direction of unlicensed. And also really having a conversation with them of what it takes to put employee, if they're going to pay them salary, the taxes, that legal side of it versus an independent contractor, because so many of them, they're used to getting the commission check that we're independent contractors. And when you start adding all of the different taxes and social security taxes and stuff, and it really gets to be a bigger thing than what they realize.
And you mentioned broker policy manual, so I just wanted to make sure everybody was aware out there that there is a new model ADRE broker policy manual. Holly Esslinger, who is a saint, worked with the Department of Real Estate to accomplish this, and it was a lot of work on Holly's part. But a good, solid document was developed, and so if you're looking to create a new broker policy manual or update yours, go on ADRE's website, take a look at that one, because I think that Holly did an excellent job.
So Scott, can an unlicensed assistant perform such tasks as uploading photos on MLS listings? And also, can they be paid based on listings taken versus closing?
All right, so let's break those down. The first one is uploading photos, taking MLS listings, participating in the MLS upload. And I think the answer to that is yes. Again, we go back to the substantive policy statement, and there's a list of activities that unlicensed assistants can perform, and one of them is using technology as a tool to complete tasks assigned by a licensee. So if a licensee says, please upload this photograph, please enter this information in, I think that's using technology as a tool to accomplish the instructions that you've been given. What was the second part of that question? Because it sounded hard, so maybe Rick can answer that.
Yeah, thanks.
They're wanting to know if you can pay this unlicensed person based on listings taken versus closings.
Listings taken is a little bit dicey. Here's what you can do. Number one, closings, no.
Yeah.
Number two, you can pay them per task. For instance, it's $2 to upload photographs on MLS. I mean, if there's a compensation package that's tied to work that they do, that's going to be okay. I'd rather it just be a straight $8 an hour or $15 an hour, whatever the case may be. So I would avoid that, because it's going to get you on the slippery slope as well. We're going to have to pay for this and this and this. Next thing you know, you've got a commission-based program. I would avoid it, but I think technically if you paid per work, again, X dollars for doing X task, you're going to be okay with the statutes and the substantive policy statement.
Yeah, I like that. I like the idea of the per tax or per performance, per issue. I think that's a good way to go about it.
And Nicole, is anything being done by AAR to lower the excessive charges by management companies to provide the required HOA disclosure?
So a few years back, we passed legislation that would restrict the document disclosure fee to $400, which was to be paid upon close of escrow. We had some individuals bring it forward at the Legislative Caucus that we do look into this and potentially go back and tighten up some of the language. I think it's important to understand that the document disclosure fees are capped at $400. So oftentimes we do have members who come forward and say that some of these fees around HOAs are very high or excessive. With regards to what is in statute on the $400, there's different fees and different variations of what they call them, but they're not necessarily illegal, correct?
Yeah.
And we have the $400 and that is capped. So we are reviewing it. I think it's important to note, though, we are not looking to reduce the $400 cap on there. And when we do look at areas of statute, we do open them up, we have to remain cognizant that by opening these areas of statute up, we also open it up for other entities to come in and move forward with what they would like to see. When this was originally passed, the industries that represent the management companies wanted to tie it to an escalator, and they wanted to use the CPI as the escalating fee that would be moving the bar up every year. The number kind of hovered around 3%. And so what effectively that would do is over the course of time, it would completely blow out the $400 cap, and then we would be right back to where we were once again. They have floated this idea as possibly coming back. So we need to make sure that if we are to open up the statute, that we do not risk what is currently in place. And I do believe that the majority of our members would probably rather see the hard cap not move going down the line than for us to open it up, get a small win, but yet lose at the same time. And Scott?
Yeah, and I'll get calls from members on occasion saying, they're charging a $500 transfer fee. That's above the $400 cap. Again, as Nicole indicated, the $400 cap applies only to the disclosure fee, which is the HOA or the management company providing the documents that they're statutorily obligated to provide. It doesn't apply to transfer fees. It doesn't apply to capital improvement fees. Those are other sorts of fees that are set forth in the CCR. So in other words, that's part of a private contract between the HOA and the homeowner. The government's not going to get involved in that. The disclosure fees were the ones that were being abused. You know, $1,000 to photocopy some documents, put them in the mail, and ship them off is grossly excessive. And so AAR did step in, run the legislation that Nicole talked about, and establish that cap. But you have to remember, it pertains to the disclosure fee, or the disclosure of documents. It doesn't matter what they call it. If it pertains to the providing the statutorily required documents, it doesn't matter what they call it, that's capped at $400.
Yeah, and for the next legislative session, as we will and have done for the last few, we'll be reviewing the legislation, and if anything comes out and is introduced that specifically addresses the document disclosure fees, we're going to fight on behalf of the member and the homeowners to make sure that, you know, what's currently in place isn't eroded.
What about open house signs? Is there any legislation pending or that you're considering that might seek to limit how many open house signs you can put out?
Well, we are not going to seek to limit open house signs. I can say that. And there was nothing specifically as limitation of sign placement out of the caucus. But as we discussed a little bit earlier, we do have the sign legislation that would include for sale, for lease, open house signs. We do anticipate moving that forward. But specifically as it pertains to open house, I do not have any legislation to limit sign placement.
So Rick, can you offer any clarification on rental property inspections by non-licensed persons?
Yeah, we touched on that briefly. It's the short answer is the non-licensed person, per the policy statement, may not conduct an inspection, may not go in, especially do the either pre-possession checklist or post-possession sort of checklist as well. They should be done by a licensed real estate salesperson.
So Scott, what kind of licensing is required by ADRE for a salesperson's assistant?
Well, it really just depends on whether the assistant is doing work for which a license is required or whether they're just performing administrative tasks for which no license is required. There's really not different classifications of licenses in that regard. You either are obligated to have a license or you're not obligated to have a license, and it solely pertains to the type of work that you're performing. If you're performing work for which a license is required, you have to have the license. If you're not, you're good to go.
And then people like rules, so here's the short answer. If it's clerical or administrative, you don't need a license. If it's something that's going to require somebody to exercise some discretion, make a decision, so on and so forth, a license is generally going to be required. And if you get close to the line, just don't do it. Go do it yourself. Don't send your unlicensed assistant out there.
Nicole, is there still a moratorium on rules changes for departments in Arizona?
Yeah, there certainly is. Actually, the rule moratorium was put into place by Governor Jan Brewer back in 2009, and upon being elected, Governor Ducey issued another executive order that extended the rule moratorium. And quite honestly, moving forward, I don't foresee that being lifted. So short answer is yes.
Yeah, and Nicole, correct me if I'm wrong, but it seems like the political climate right now down at the Capitol is not for more rules, it's actually for less.
Yeah, and you're correct. Actually, Governor Ducey, one of his goals is to make access to business easier for people across the state. And so he does not want to see more regulation placed on any industry, to be quite honest. And in fact, he's had some bills go through the legislature about 2 years ago that removed licensure. And though we are not in,
Right. Yeah, I was going to say, make sure before everybody gets into a panic.
just very clear, that is not on the table, and the governor's staff has actually very publicly stated at no point does he have the intent to remove the real estate license in place. It's something that we remain cognizant of, and we don't want to move forward with legislation that is going to be in direct opposition to what he'd like to see, which is less regulation. And when we are down at the Department of Real Estate, we also, are very clear that we have to work within the confines of what is currently before us, and hopefully not move forward with a violation of what he'd like to see.
Yeah, where we seem to run into this, Nicole, is when members will come to us and say, we want an increase in the number of mandatory continuing education hours, or some of them say we want a decrease in the number of mandatory education hours. But again, it's governed by rule.
Correct.
And so the department is their hands are somewhat tied.
Yeah, correct. Their hands are somewhat tied, and unless there was a real push at the state legislature to change, if we're talking about continuing education, which there really isn't one, I don't foresee the department being able to make any sort of change. And a few years back, under the rule moratorium, we did work hand in hand with the Department of Real Estate, and we did go through the rules, and we did see areas that needed to be addressed and maybe changed. There's really no appetite for it. So until it's lifted, I don't see any movement happening there.
So with marketing and unlicensed assistants, where's the line? What can they do? What can they not do?
They can prepare marketing materials. That's certainly something that's allowed, but all marketing materials have to be approved by the broker. So again, it's the clerical issue. A lot of marketing materials is clerical in nature, right? If I'm hiring a graphic designer in Nevada to prepare some flyers for me, they're not going to be licensed individuals, right? Because they're just preparing marketing materials. So I think that's how you have to look at it from this standpoint, or from the department's perspective.
And a related step, interacting with the public is a no as well. If you're out soliciting business with buyers, sellers, whomever, same idea. That's something a licensee should be doing.
Even if even a member of the public calls and asks what the list price is, or has some general questions about the property, an unlicensed assistant has that information right at their fingertips, Commissioner Lowe's taken the position that really that information needs to be conveyed by the licensee.
And this question keeps coming up, so I just want you to clarify again. When you have an unlicensed assistant in your office who is accepting rent checks, that is acceptable, not acceptable?
Unlicensed assistants, no, cannot be sitting there as an intake for rental payments, whether it's a check, whether it's cash, the writing of receipts in return for that. Commissioner Lowe has taken the position again, all of that needs to be done by a licensee.
So Nicole, is there any movement to amend the law allowing unfettered Airbnb rentals in older neighborhoods?
So this is an interesting one. No, I haven't seen anything in the last year to restrict the Airbnbs from being within neighborhoods. Currently on statute, the only way that there really is a restriction is if it's in their CCRs, and it's the rental restrictions. Now, with that being said, there's a number of communities that since the Airbnb kind of became more of a big deal here about a year and a half ago, there are some associations that are amending their CCNRs to place those restrictions for short-term rentals, in their documents, which is perfectly legal. I imagine there will be somebody who brings it forward who asks their legislator, oh, we need to have these restrictions. I don't necessarily know if it really matters if the neighborhood's older or younger or whatnot. I'm not seeing it in neighborhoods where there's no CCN, no homeowners association, just those with HOAs, and even beyond that, I think it's few and far between that are actually able to accomplish it. You do have in your condominium complex a higher threshold for voting to amend the CCNRs. In planned community neighborhoods, it's not a higher threshold, but a lot of them do set within their CCNRs a higher one. It just depends on the particular community. Scott?
Yeah, I wanted to ask Carrie, are you seeing more and more buyers purchasing properties specifically as short-term rentals? And do the agents do anything different in those sorts of transactions?
We haven't seen that with
Okay.
it. I have relatives that do it, so I hear it from there. But as far as people specifically buying it for that purpose, no, I see them more like they'll subsidize what they've already had, help them make payments or something like that.
And I think the agent needs to be careful in taking any sort of position of, oh, you can use this property for this purpose, you can't use it for this purpose. That's really something buyers should be investigating for themselves.
Yeah, and remember there's that state statute that says cities and towns shall not restrict short-term rentals. And people get that confused with CCNRs, and Nicole has it exactly right. CCNRs can be more restrictive. A lot of times they are. If there's a prohibition against rentals or even operating a business, that some people try to slot it in under business, then the CCNRs would be enforceable regardless of the state statute.
And buyers really need to look at those CCNRs. They're given an opportunity to do that in the contract and disapprove, and they really need to take some time, especially if there's a specific issue, right? They want to park an RV on the side of the house. They want to use it as a short-term rental. You really need to take a look at those CCNRs before you close escrow to make sure that your intended use of the property is in fact permitted.
So no webinar is complete without a medical marijuana question. So if the lease says medical marijuana cannot be used, grown, or consumed in the home because it is federally illegal, is that legal, even if it's legal in the state?
That's a loaded question, and go see your lawyer because it's going to be fact specific. Let me tell you this in general. Yes, the Controlled Substance Act makes it illegal on a federal level. The tension is that arguably somebody who has a medical marijuana card has a handicap, so therefore excluding them or not renting them could be a fair housing violation. Sort of the compromise is you can say as a landlord, no, you may not grow, no, you may not cultivate, and you may not smoke inside. You may consume inside with the edibles or whatever else, but smoking inside is probably an issue. Tough call. If you have real issues with it, go see your own lawyer and deal with it specifically, because candidly, the federal law and state law are in conflict, and there is no real clear answer right now.
Great. Well, thank you. That is all the time we have for today and our first ever video broker brief webinar. We hope you've enjoyed it. Scott wants you to know he's not normally this pale.
No, this lighting is not working for me at all. No.
So our next broker brief webinar will be on December 13th, and we hope to see you there. Have a great day.